Ladies and gentlemen, we have come to the end of our case. Thank you for your attention and cooperation throughout this trial. Soon the judge will instruct you on all the jury instructions in law regarding this case, including the presumption of innocence and reasonable doubt. The state has the sole burden of proof in this case. The defendant does not have to prove anything. And don't be misguided to think because he testified somehow that reverses the burden of proof. The burden remains with the state throughout the trial until you all reach your verdict. In our country, a defendant does not have to prove himself or herself innocent. That would violate the due process of the law. Our judicial system is designed with a built-in safety valve. The safety valve is the burden of proof, beyond a reasonable doubt. It is a high standard to meet for the state because its purpose is the most noble. It is designed to prevent people from being wrongly convicted, and also to prevent people from being convicted of crimes, higher crimes than what they committed. Not guilty means not proven beyond a reasonable doubt. You all agreed that you would sit here as impartial jurors and look at all the evidence with common sense and an open mind and give Mr. Matos a fair trial. Ladies and gentlemen of the jury, you have to decide what the truth is in this case. You are the fact finders. Mr. Labruzzo explained that to you during jury selection. You determine what the facts are, not the judge, not the state, not the defendant, not the witnesses. You and you alone are tasked with the job of determining the facts and what they mean. I submit to you that the only way that you can gauge the accuracy of what has been asserted here by the state is by analyzing how it matches up against the actual physical evidence that law enforcement went through great lengths to preserve. And after you determine the facts, you have to apply them to the law. You are the law appliers. You're going to have to do your analysis 4 times. Once for each crime the state is charged. Let's begin by looking at the law. Mr. Sarabi already went over some of these jury instructions with you. I don't want to repeat what he said, but in order to help you understand the logic behind the range of homicides, we need to start with a concept known as mens rea. Mens rea is a term used to describe the level of intent someone had when they committed a crime. Let me give you an example. A driver who accidentally runs over a pedestrian has not committed any crime, so long as he doesn't leave the scene of the accident, of course. Even if the pedestrian dies, the driver has not committed a crime if the crash was accidental. That is, it was a result of the driver being negligent or careless, because the driver didn't intend or want to harm the pedestrian. This concept isn't difficult to understand. Even kids know that if they break something by accident, they shouldn't get in trouble. That situation, ladies and gentlemen, is called an excusable homicide. One can be sued civilly for wrongful death and have to pay a lot of money in damages, but he won't go to jail because he didn't commit a crime. NG here for not guilty. This is excusable homicide. Now, on the other end of the spectrum, if someone wants to kill someone and aims their car at them and runs them over on purpose, then that person is guilty of murder, except if he was acting under a heat of passion, which I will get to in a minute. So on this end, we're going to have we have 2 types of murder. Murder in the 2nd degree, murder in the 1st degree. In the middle of these 2 extremes, you have manslaughter. An example of manslaughter in a motor vehicle context, ladies and gentlemen, is a situation where the driver does not mean to kill the pedestrian, but his behavior isn't excusable because he wasn't just negligent, but he was culpably negligent or reckless. He didn't want to kill anyone, but he was driving so recklessly that he knew that there was a good possibility that he could kill somebody and just didn't care. This could be a situation where someone is speeding 100 miles per hour, running red lights, weaving in and out of traffic, fatality occurs. that person has committed manslaughter. Justifiable homicide is when one kills someone in self-defense, like Mr. Sarabia said. Back to the motor vehicle context. If a person is sitting at a red light and a crazy person gets out of the car in front of them and points a rifle at them, they would probably be justified if they ran them over. Finally, if one kills intentionally in a heat of passion, they are not guilty of murder. They are guilty of manslaughter. In that situation, the default homicide, if you will, is manslaughter. For instance, if a guy is driving down the street and he sees his best friend, who he just found out is sleeping with his wife, and the so-called best friend provokes him by swearing at him, and the driver loses his mind and runs him over in the heat of passion, it's manslaughter, neither murder. It's manslaughter even if he aimed at him and intended to kill him, so long as he acted in the heat of passion. In homicide cases like this one, if there is evidence of self-defense, that his state has to prove, in addition to all the other elements, beyond a reasonable doubt, that the defendant did not act in self-defense. In other words, they have to prove it wasn't justifiable homicide. In addition, if there is evidence of heat of passion, and I submit to you there is evidence of heat of passion in this case, the state has to prove beyond a reasonable doubt that Mr. Matos did not kill in a heat of passion. If they're unable to, the most serious crime you can convict him of is manslaughter. Now, ladies and gentlemen, the state will get up after I sit down and do their rebuttal, part of their closing argument. Don't think that manslaughter is not an option in any one of the crimes charged in this case. Matos' intent may have been more than recklessness. To be found guilty of manslaughter, your intent level has to be at a minimum culpable negligence. It can be intentional, and many times it is, so long as you acted in the heat of passion. Now, in my opening statement, I told you that this case, at its core, is about self-defense, which is the same thing as justifiable homicide. This here is the jury instruction for justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house which the defendant was at the time of the killing. You will also receive another jury instruction on justifiable use of deadly force, which is similar but explains that if a defendant is not otherwise engaged in criminal activity and it was in a place he had a right to be, he had no duty to retreat. I submit to you that Mr. Matos never had an opportunity to retreat with regard to Nicholas Leonard until Nicholas Leonard fell unconscious. Mr. Matos was a tenant in this house. He paid rent. He had a right to be there. Now, if police were called from the earlier report, the police may have taken him into custody for the earlier event, but he was not committing a crime when he entered 7719 Hatters Drive on the evening of August 28, 2014. Ladies and gentlemen, Mr. Matos pled not guilty to all the first-degree murder charges that the state filed against him. I submit to you that he did not commit any first-degree murder. He chose to testify in this case, even though he had a right to remain silent. He admitted to killing Nicholas Leonard, Gregory Brown, Megan Brown, and Margaret Brown, and testified in detail to the circumstances surrounding the killings, which are consistent with all the evidence in this case. As a U.S. citizen, he has the right, we all share to receive a fair trial and be convicted of the crimes he actually committed. Only the crimes that the state proved beyond a reasonable doubt. I submit to you that with regard to Gregory Brown, that killing was a justifiable homicide. And we ask that you find that Adam Matos was not guilty of any crime with regard to Gregory Brown. He did not have a duty to retreat. He was defending himself. The state has not proven beyond a reasonable doubt that it was not in self-defense. Similarly, with regard to Nicholas Leonard, I submit to you that that killing was also a justifiable homicide, and we ask that you find that Adam Matos was not guilty of any crime with regard to Nicholas Leonard. The state has not proven beyond a reasonable doubt that it was not in self-defense. The state has not proven beyond a reasonable doubt that Nicholas Leonard had not passed away before Adam Matos hit him with a hammer. Dr. Palmer testified, the first time he testified, that Nicholas Leonard could have bled out and died within minutes from the injuries to his arm alone if the bleeding was not controlled. Now today he testified a little bit differently. You use your memory as to what he testified to. Today he said something about clamping an artery. I submit to you, there was no medical treatment to Mr. Leonard on the date of August 28, 2014. There was no clamps inserted into his arteries, and he was bleeding from his arm. If you disagree, however, I submit that the state clearly, though, has not proven that Adam did not act under a heat of passion. When he killed Nicholas Leonard. In other words, if you find that the state proved beyond a reasonable doubt that Nicholas Leonard was still alive and only unconscious before Adam went back into the room the second time, then you could find that he overstepped his right to self-defense and committed a homicide. But that homicide, I submit to you, ladies and gentlemen, is manslaughter. With regard to Megan Brown, I submit to you that killing was also a justifiable homicide, and we ask that you find that Adam Matos was not guilty of any crime with regard to Megan Brown. I'm going to read to you a jury instruction that the judge is going to read to you, and it says, in deciding whether Adam Matos was justified in the use of deadly force, you must consider the circumstances by which he was surrounded at the time the force was used. The danger need not have been actual. However, to justify the use of deadly force, the appearance of danger must have been so real that a reasonably cautious and prudent person under the same circumstances would have believed that the danger could have been avoided only through the use of that force. If, however, you disagree, you are the fact finders, you are the law appliers. If you disagree, we ask that you find him guilty of manslaughter, because again, the state has not proven that Adam did not act under a heat of passion when he killed Megan Brown. Finally, with regard to Margaret Brown, we ask that you find him guilty of manslaughter. Again, the state did not prove beyond a reasonable doubt that Adam did not act under a heat of passion when he killed Margaret. However, if you disagree, you will be given all the jury instructions. If you disagree, we ask that you find him guilty of second-degree murder, because the state did not prove beyond a reasonable doubt that the homicide was premeditated. Premeditation is another element that the state has to prove beyond a reasonable doubt in order for someone to be convicted of the highest crime of the land, first-degree murder, as opposed to second-degree murder. Both are very serious, but obviously first degree is more serious. The state has argued and will undoubtedly argue again that one can establish premeditated intent required to commit first-degree murder in seconds. And that is true in certain cases. However, each case is unique and must be judged within the context of all its facts. In our case, Clearly, Adam Matos didn't move down to Florida from Pennsylvania so he could kill the Brown family. After carefully considering, comparing, and weighing all the evidence, if there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. The judge will read to you that a reasonable doubt as to the guilt of the defendant may arise from the evidence, a conflict in the evidence, or a lack of evidence. If you have reasonable doubt, you should find the defendant not guilty. An example of a conflict in the evidence? The state throughout this trial has tried to show in their case that Adam Matos was in some kind of platonic relationship with Megan when they came down to Florida. That is obvious. I submit to you that's obviously not true. They're talking out of both sides of their mouth. On the one hand, Adam and Megan's relationship is platonic because the state does not want to concede that Megan Brown was unfaithful to Adam Matos. But on the other hand, with the quantity of phone calls between Adam and Megan, they want to imply he became mad and wanted to kill her because he was a jilted lover. Well, which one is it? I submit to you, the state doesn't know. They want convictions for first-degree murders, but they don't know what happened. But in the end, the facts in this case and all the physical evidence make it clear that this case is a self-defense case at its core. The state has not produced one iota of evidence that shows Adam Matos was armed when he went to 7719 Hatters Drive on August 28th of 2014. Instead, what did it focus on? Instead, it focused on the smell of decomposition, the selling of dogs on Craigslist, pizza deliveries. Because all of the evidence in this case shows that Adam Matos was not the aggressor on August 28th of 2014. Nicholas Leonard, Gregory Brown, and Megan Brown were. Actually, Adam Matos would have been a real fool, I submit to you, ladies and gentlemen, to walk into the wasp's nest that was waiting for him on August 28th of 2014. Adam Matos didn't know Nicholas Leonard was there. Leonard had parked in the empty lot across the street. Adam thought Megan was at work. The physical evidence in this case is a virtual map of what happened. Self-defense is the only explanation that makes sense. Use your common sense, ladies and gentlemen. Adam Matos knew that Gregory Brown had an arsenal of weapons. If he had planned to kill these people, he would have snuck into Greg's master bedroom closet while Greg was outside working on the RV. He would have armed himself with one of the semi-automatic Browning rifles found in the canal. You heard the evidence. Gregory Brown and Megan Brown were killed with what? With the Kel-Tec pistol that was owned and brought into the home by Nicholas Leonard. There was clearly a struggle with Nicholas Leonard in the southeast bedroom. The bloodstains all over the room are consistent with a struggle. The evidence is not consistent with Leonard being killed while he was asleep on the mattress. And remember, all the people, when they were found, were fully dressed in daylight clothing. Nobody was wearing pajamas. I know it's Florida. Few of us nowadays wear pajamas, but they weren't in their underwear. If I'm not mistaken, cargo shorts, jeans. There was evidence of blood, substantial volumes of his blood dripping all over the room. On the chair, which was open at the time, according to Anna Cox, the window fan, drops, and if you look at those pictures again, there was drops near the dresser. In front of the dresser, you will see drops of blood. Near the CD tower shelf, on the curtain in the southeast part of the room, in front of the house. We know from the autopsy report that Nicholas Leonard was cut deeply on his left arm. Adam cut his arm with a knife. Ladies and gentlemen, if Adam Matos was the aggressor, that knife wound would have been to the stomach, or the neck, or the torso. It would have been a strike to kill, but it was to the arm, to wound, not to kill. The bullet hole in the bedroom wall is more evidence consistent with a struggle. Forensic investigator Nancy Selinsky testified that it was 46 inches from the ground. And the trajectory was an upward angle. So it was lower before it hit the wall. What does that indicate, ladies and gentlemen? I submit that indicates that the shooter of that gun was lying down on the mattress in the southwest corner. What else does that physical evidence show us? What conclusions can we draw? Well, it is obvious that Nicholas Leonard, Gregory Brown, and Megan Brown were killed in two separate rooms, which means Adam would have to travel between rooms. We know that there was a transfer stain of Nicholas Leonard's blood at the entrance of the master bedroom walk-in closet. We know that from Anna Cox, which would mean that Nicholas Leonard was clearly injured first by Adam Matos. There was none of Gregory Brown's blood in the southeast bedroom. There was no physical struggle between Adam and Gregory Brown. Once Greg Brown was shot, he stayed down, and per Dr. Palmer's testimony, day one, probably died instantly. Gregory Brown was in the closet with the guns, so Adam's testimony is again consistent with the evidence. So is the location of Megan Brown's blood and the corner bead bullet hole. If you recall, Dr. Palmer's testimony from his medical autopsy report said she was 5'8". The hole in the corner bead was, per the testimony of forensic investigator Selinsky, 5'5" high. 5'8", 5 foot high, difference of 3 inches. This places the bullet in her eye. That is why there's not a bullet hole if you follow a trajectory from the closet. And that's why you have a missing bullet. It's not missing. It was recovered during the autopsy of Megan Brown. This is consistent with Detective Kugel's theory. The bullet, it lodged itself in the back of Megan's skull because, I submit, the corner bead weakened its force. How do we know that Adam's telling the truth about running after Gregory Brown and Megan Brown, killing them first, and then returning to the southeast bedroom to hit Nicholas Leonard with the hammer? Because if he stayed to strike Nicholas Leonard repeatedly, especially after everyone would have heard the 2 gunshots that went off, Gregory Brown would have had enough time to load another rifle and confront him somewhere in the middle of the living room. The big question, ladies and gentlemen, is why, if Adam was the attacker, Megan didn't take little Tristan and run away from the house out the front door screaming to neighbors like Ryan McCann for help at the first sight of Adam. I published a photograph that I put into evidence. You can see, as clear as day, that southeastern bedroom is right next to that front door. Freedom. Why didn't Megan Brown escape this house? Why didn't she call 911? She clearly had time to call 911. The order people were killed is the same way Adam describes. Adam wouldn't have a gun to shoot Megan Brown in the master bedroom if he didn't first eliminate the threat Nicholas Leonard posed. That is only logical and makes common sense. What doesn't make sense is why she never bothered to run or call 911 at the very start. I submit to you that she had several minutes. Law enforcement, I think, that it was one of the 911 dispatchers who testified that had she called, they would have been there in minutes. They already had her information from the morning call, her number, her address, Adam's pedigree. Calling and hanging up probably would have been enough. They would have sent somebody out in minutes. There's no record that she ever called 911. It's a mystery. Unless you use your common sense and factor in that she never thought Adam would survive. Nicholas Leonard had the gun. Nicholas Leonard was going to solve all her problems with Adam Matos. She would be free to raise her child any way she chose. I submit that nobody actually wanted Adam to move to Florida. They brought him down to avoid custody issues in Pennsylvania. I submit Adam couldn't really have a custody case in Pennsylvania since not only had he consented to the move, he moved with Megan and Tristan to Florida. Megan Brown didn't call the police, ladies and gentlemen, because she never imagined Adam would survive Nicholas Leonard's Kel-Tec pistol. She never imagined that Nicholas Leonard, with a gun in his pocket and a backup knife on the dresser, would fail in his attempt to kill Adam Matos. The only reason she ended up in the master bedroom with Gregory Brown is because it happened just as Adam testified. The fact that Megan stayed in that house with Tristan, her 4-year-old, proves who the primary aggressors were. It would have been a very successful stand-your-ground case in Florida. They would have effectively removed the third wheel and got away with first-degree murder, if not for fate, if not for that one bullet stuck in the chamber of Gregory Brown's Winchester. Ladies and gentlemen, the state has introduced a lot of evidence, days of hundreds of photographs and testimony, but they neglected to share with you that Gregory Brown's Winchester was loaded. Actually, they put on testimony via his son and other witnesses that gave the impression that Gregory's rifles were locked and secured and always unloaded for the safety of little Tristan. It was the defense that was able to bring out during the cross-examination of forensic investigator Rare Clark that the Winchester 30-30 lever-action rifle was loaded with one single bullet. In the end, ladies and gentlemen, a trial, when properly conducted, is supposed to shed light on the truth. There's nothing more beautiful than the truth. That bullet in that rifle in a house with a 4-year-old toddler is another mystery that needs to be explained, not ignored. The devil is in the detail. It is analogous to putting together a puzzle, and near the end, being stuck with pieces that don't fit and discarding them. Ladies and gentlemen, it's not that the piece doesn't fit. It may be that the state doesn't like the picture that it shows. I submit to you, ladies and gentlemen, that that piece is what unravels what happened on the evening of August 28, 2014, when you put it together with all the other pieces. The bullet holes in the southeastern bedroom, the bullet with Nicholas Leonard's DNA, the bullet hole in the master bedroom, the location of the bloodstains, it's all there. Adam Matos testified truthfully when he explained what happened. And he didn't have to testify. The bullet is the jam bullet that Gregory Brown tried to kill him with. This is an example of reasonable doubt from the evidence. Ladies and gentlemen, the state is trying to fit a square peg into a round hole. All the state attorney is relying on is speculation and unfounded theories. That isn't proof beyond a reasonable doubt. Ladies and gentlemen, they promised you that they would prove this case beyond and to the exclusion of every reasonable doubt. But in the end, they want you to trust them and take a leap of faith. The state's job is to eliminate all reasonable doubt in the proof of their case, not hope that you overlook the discrepancies. If one goes to an expensive restaurant and orders a fine meal and they find a hair in their food, they're not going to pull out the hair and eat around it. They're going to send it back. Send it back. The state was confident when they promised you that they were going to prove to you that Adam Matos committed 4 first-degree murders. If they haven't met their promise, send it back. Example of lack of evidence. The state has presented no evidence of premeditation. The state is relying on the 911 call that Megan Brown made at 5:30 in the morning, after staying up all night on a weekday at a bar. Adam was upset the night before for several reasons, including the fact that he had to work the next day, and Megan was supposed to be watching Tristan while he worked. Ladies and gentlemen, if Adam wanted to kill Megan, he chose not to when he had the chance. Remember, the majority of those calls that the state is basing its prosecution on, calls that you have no content for, that we can only speculate what was said on those conversations, the majority of those calls were made to her prior to 5:30 in the morning. When he pulled out the knife on her, she grabbed it and cut her thumb. If he wanted to kill her, he would have done so then and there. Instead, he chose to drop the knife when his little boy woke up. And he decided to leave. I submit to you that if on August 28th of 2014 at 6 p.m. when Adam came back home, if Megan told him to leave, he would have left. Ladies and gentlemen of the jury, you have all experienced all types of things in your life. You range in different ages. You have met all types of people. You also can recognize and identify all types of behavior. The state undoubtedly will play that 911 tape again when I sit down, and you'll have a chance to play it again yourselves if you want to. If you do, please pay attention to the part when Megan Brown thinks that she got mistakenly disconnected by the 911 dispatcher. This is located near the end of the audio after 7 minutes. She completely stops crying and moaning and says, "Hello? Hello?" until she knows the dispatcher is still there, and then the moaning begins again. I submit to you that Megan Brown may have been exaggerating what happened in the morning between herself and Adam. She describes a 1/2 inch cut on her thumb as being so deep she could see her flesh. Is she sincere on this audio, or is she deceiving? You decide. You're the fact finders. She recognized, I submit, that this report of domestic violence was a perfect way to get rid of Adam. Phone calls. Again, instead of hard evidence, the state is trying to base its prosecution on empty phone records without the content of the conversations. The evidence is meaningless. In our country, we do not convict people of crimes, especially first-degree murder, based on speculation. With regard to the phone records, if and when you review them, please make sure to identify Nicholas Leonard's number, 727-488-8804. As was brought out from the testimony of Detective Kugel, he talks with Adam at least twice on the early morning of August 28th for 2 conversations, 22 minutes each, for a total of 44 minutes. It's worth noting that Nicholas Leonard texts Adam Matos first, before those conversations begin. So it's Nicholas Leonard that reaches out to Adam Matos, consistent, again, with Adam Matos' testimony. Now ask yourselves, what 2 men have ever had a phone conversation for 44 minutes? Do you think they were arguing for about an hour? Cussing and threatening each other for about an hour? If those conversations were acrimonious, I suspect they would have been really short. They were obviously talking about something. Mr. Matos testified as to what they were talking about. Mr. Leonard was feeling doubts about whether he wanted to continue seeing Megan Brown. He was identifying with Adam. They also talked on the phone around 6 a.m. before Nicholas Leonard knew about the incident between Adam and Megan. Remember, Nicholas Leonard didn't find out about the incident and didn't call 911 until after 9 a.m. Mr. Leonard was not an enemy of Adam Matos. Nicholas Leonard did not betray Adam Matos in any way. I submit to you, after talking with Megan Brown, Nicholas thought it was his duty to save his damsel in distress. Please note, he only knew her for weeks. Please also note that Adam's last call to Megan was at 4:12 p.m. on August 28th. Also, there were no calls to Megan Brown from Adam between 8 a.m. and 4:12 p.m. Again, ladies and gentlemen, there is no evidence of premeditation, no evidence of planning by Adam Matos to kill these people. Premeditation is planning something beforehand. That's literally the meaning of the word. Let's take a look at how well Adam Matos planned these so-called crimes. First of all, I said in my opening statement, he never tried to get away. 7 days and he stayed there. He had credit cards for gas and an RV. It would take, I submit, it would have taken only 2 days to make it to Guatemala or about anywhere else in the continental United States. He could have sold the RV and lived comfortably for a couple of years. Instead of premeditation, all you have is amateur improvisation. The decomposition smell alone that the state kept proving over and over and over again proves as much. If you're going to plan a murder, you're going to plan how to get rid of the bodies. Adam didn't even have a shovel. He was so in shock. He didn't know what to do. He bought a shovel from Walmart after 24 hours after Margaret's death. The bodies were lying in a pile in the east garage near the two-wheeler where Anna Cox described a pool of blood for at least 24 hours. That's why you had that smell. That smell proves no premeditation. He tried to dig a hole in the dirt but abandoned the idea. He hauled the bodies about a mile from the house and left them in a ditch. He didn't try to get away with it. He tried to escape only in his mind by pretending it never happened. Ladies and gentlemen, the bags on Margaret's head are a very important point in this case because if the state is able to convince you that Adam suffocated this woman, then they have a better chance. Ladies and gentlemen, Dr. Palmer last week testified pretty accurately on this issue. He made it clear and agreed with me that there was no physical, biological evidence of suffocation or asphyxiation. He explained that he put asphyxiation in his report as a contributory cause of death simply because of the presence of the bags, not because of an opinion reached through his expertise. Remember, he didn't know about the blood spatter evidence in this case. His job was just to do a physical examination of the body. He did go to the place where the bodies were found and saw how they were positioned and dressed, but he had no other information regarding this case because that would be outside the scope of his job. He testified only that asphyxiation may be a cause. And ladies and gentlemen, he did the autopsy at the beginning of the investigation, long before Jacqueline Angelo, the FDLE crime laboratory analyst, did the DNA testing, and Anna Cox, the very accomplished and articulate bloodstain pattern expert, analyzed the bloodstains. Anna Cox testified that there was a blood spatter event on the north wall of the west garage, the narrow hallway before room K, where the stairwell is. All the state's experts are in agreement on this point. Dr. Palmer agreed with me that if there was blood spatter event from Margaret, then that would prove that the bags were placed over the head after the blood trauma. It's not a complicated issue to understand. Liquid cannot pass through a solid. In this case, through two unbroken bags. You don't need to have an MD or any other degree. All you need is common sense. I submit to you, ladies and gentlemen, that the laws of physics were not temporarily suspended on August 28, 2014 in the West Garage at 7719 Hatteras Drive. Mr. Labruzzo promised you in jury selection that you could use your common sense when you decide the facts of this case. Dr. Palmer doesn't know the facts of this case. You do. And you can use your common sense to decide what makes sense because you're the jury. I submit to you that the state has not proven beyond a reasonable doubt that Margaret Brown was suffocated. Also, if Margaret Brown suffered the heavy blow that caused that 6 centimeter hole on the side of her head, wouldn't the bag be punctured? I submit it would. But yet, the state didn't show any evidence of damage to the bag. And Dr. Palmer testified to liquid in the bag that had not leaked out. I also want to clear up something that might mislead. The doctor's testimony and report described the tape around the bag as electrical tape. We all know what electrical tape looks like. It's about less than a ½ inch wide. It's black. Dr. Palmer, in his gestures the first day he testified, said that Margaret's face was covered, and he gestured something like this, giving the impression of wide duct tape. That's not the case. The tape was less than 1 inch. Also, if there was tape like duct tape under the bag, over the mouth, clearly that would be evidence of suffocation. But common sense dictates that tape over a bag will not increase the chances of suffocation. One other thing I suspect, actually I don't have to suspect, Mr. Sarabia came up here and argued that somehow Margaret was killed first. Talk about crafting stories. They locked themselves up relying on the testimony of Justin Oken's testimony to narrow the time of the deaths. In spite of the fact that they haven't proven beyond a reasonable doubt when the alleged crimes took place, because there's overwhelming evidence, including from Okens himself, that in this area gunshots are common. I submit that the state will not concede this point, and they're trying to shape their argument to fit this timeline. Let's look at the timeline. Margaret left work at 11:11 p.m. Detective Kugel testified it would take her 50 minutes to get home. That would place her home at 11:26 p.m. Per Oken's testimony, gunshots were between 11:45 p.m. to midnight. That means Adam must have killed her in the garage first and then went upstairs. That's what the state's arguing. The problem with that is the physical evidence and common sense. With regard to physical evidence, there wasn't a drop of Margaret's blood found on the second floor. There were no transfer stains. The hammer would have been contaminated with her blood when the blood spatter event occurred. There were transfer stains in the west garage near the fridge, but nothing on the second floor. With regard to common sense, how about the 20-odd dogs in this house? Wouldn't they sound the alarm? Wouldn't Megan or Gregory Brown or Nicholas Leonard have heard Margaret pull into the garage or felt the shutter of the garage underneath? Can one sense when their garage door opens and closes? Even in houses where the garage isn't on the first floor, when it's adjacent to the house, I submit to you, you know when your loved one's coming home because you hear the tremble. When that garage door opens and closes with that loud chain motor. I hope when the state comes back up here for the rebuttal, they have answers to these questions when they come back up. A lot of talk about Tristan's room. Mr. Matos, bad father, locked his kid up in the room. Speculation again, empty speculation. The photographs show the key part of the lock. Everybody knows what a deadbolt looks like. You have common knowledge of that. On the other side of that key lock is a turn-knob. That child was not locked in that room by Mr. Matos. Heat of passion. If you have a reasonable doubt whether the defendant acted in a heat of passion, you should find him not guilty of first-degree murder. Just like I said earlier, the default is manslaughter. In the jury instruction for both murder in the first degree and the second degree, there's a whole section that defines what heat of passion is. And there's a total of 5 elements. The first one is there must have been a sudden event that would have suspended the exercise of judgment in an ordinary, reasonable person. The second one, a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury. 3, there was not a reasonable amount of time for a reasonable person to cool off. 4, a reasonable person would not have cooled off before committing the act that caused death. And 5, the defendant was in fact so provoked it did not cool off before he committed the act that caused the death. The state has to prove all those elements beyond a reasonable doubt. Prove that they did not exist. Ladies and gentlemen, I submit to you that a normal, reasonable person is capable of losing self-control under extreme circumstances. That is why the concept of heat of passion exists under the law. The question is, how does one gauge what extreme circumstances would cause a reasonable person to lose control? This is not an easy task, and clearly not scientific. The state is asking you to take a leap of faith and find that this was not heat of passion because they say so. But if you have to guess, your conviction cannot be one that is secure and unwavering. The state has to have proven to you why this is not heat of passion. How do you decide how a reasonable person would have acted under the circumstances Adam Matos faced on August 28th of 2014? Who is the poster child for the reasonable person? All people are different. Some people are easygoing and have, let's say, a California state of mind. Others, more aggressive, like the stereotypical New Yorker. Does that mean if you're a reasonable person, if your reasonable person is the Californian type, you must find Adam Matos guilty of murder, and vice versa? If your reasonable person is the New Yorker, you must find him not guilty? Anger is an emotion that is processed differently by different people. It's easy for one to think, I would never do that. But until it happens to you, you don't know how you would react. In this case, we have a soft-spoken, polite, reserved young man, not an animated, emotional type, more the California stereotype. But look at the facts of this case, and I submit to you, you can come to only one conclusion. He snapped, and he acted in a heat of passion. The facts in this case cry out, heat of passion, self-defense, manslaughter, not murder. There was no premeditation, there was no deliberation, there was no reflection, just instinct. I submit to you that context is vital. If Margaret was the only person killed in this case, if hypothetically Megan had gone to Nicholas Leonard's house with Tristan, like his dad, Daniel Leonard, suggested, and Adam Matos had gone home to retrieve his things and no one was home, and then when Margaret came home, he killed her the way he killed her, there wouldn't be any argument for heat of passion. But killing her after the combat type experience he just experienced is not murder, especially first-degree murder. Only a combat military veteran experiences such things. You can't just bounce back from that and have a clean slate to commit premeditated murder. The killing of Margaret Brown was a link in a chain reaction that began when Nicholas Leonard made up his mind to bring a semi-automatic over to Mr. Matos' home with the intent to kill him if he showed up. Shoot him between the eyes. Of course he would show. He lived there. His boy was there. He had no other place to go. His family was in Pennsylvania. Adam Matos walked into a trap, ladies and gentlemen. Nicholas Leonard had parked his truck across the street. All of Adam's things were there. His clothes were in the closet. Remember at some point, that wasn't his bedroom. No, just coincidentally, the little closet there had men's clothing in it. Adam Matos had taken nothing with him earlier that morning. When Adam Matos walked into his bedroom on the evening of August 28, 2014, he was thrust into an unforeseeable situation in a series of events where reason, calm reasoning, and what is reasonable ceased to exist. There was no time to contemplate, no time to think. He was operating on a primal instinct to survive. That is obvious from the facts in this case, from all the evidence, from all the physical evidence. If a gun was not introduced into the mix by Nicholas Leonard, a simple 911 call on a cell phone would have been enough to make Adam grab some personal items and leave or stay and be arrested. I submit a simple cell phone gesture would have sufficed. Before I forget, I took some notes from Mr. Sarabia when Mr. Sarabia was up here. He talked about locks and a lot of speculation about locks being changed, what have you. But that hook and eyelet latch, I think it's called an eyelet latch, that was inside the stairwell door, nobody can pick that. If they were so concerned and afraid of him, a simple would have sufficed. In addition, Mr. Sarabia would have you believe that Mr. Matos admitted to putting a bag over Ms. Brown while she was still conscious. I submit to you that when Mr. Sarabia was cross-examining Mr. Matos, he used several compound sentences, double negatives. Mr. Matos is not an attorney. He hasn't been cross-examined before. He made it clear on direct examination that she was dead before he put the bag on her head. Ladies and gentlemen, I hope that the state attorney would not have you convict him because of a slip of the tongue. Because he was nervous and said something that he didn't mean to say. Now, ladies and gentlemen, you are not going to be disadvantaged like Adam Matos when you deliberate in the deliberation room in order to decide the facts of this case. You will have the leisure of time to think about all that you have heard and reach your verdict in a logical and reasonable fashion. Your verdict should not be based on instinct, but on reason, common sense, principles, and above all, the law. Common sense, ladies and gentlemen. Adam Matos outnumbered 3-1. They had guns, he had nothing. And the state just has a theory. Ladies and gentlemen, this is a very serious case. I submit to you that the whole of the state's case is the physical evidence. It is the most compelling evidence. It's not biased. It's not capable of lying. There are no eyewitnesses but Adam Matos. The physical evidence has to be without reproach, and it is. However, the state has a problem because this physical evidence supports the defense. So they're in a predicament. They have to argue against their own evidence. Like in the end of The Wizard of Oz, when the wizard says, don't look at the man behind the curtain. Ignore the blood spatter. Ignore the law of physics. Just trust us, the government. There's a French saying that says, to believe with certainty, you begin with doubting. Ladies and gentlemen, we ask you to return a verdict of not guilty as to all 4 counts of first-degree murder. Thank you for your cooperation and service in this case.